right, so if you're living in a condo, an apartment, basically any kind of strata property here in Malaysia, and you get tangled up in a dispute, things like defects, maintenance headaches, bylaw issues, that kind of stuff, then you're going to want to listen up. Today, we are breaking down a tiny but honestly super powerful rule that could completely change the game for you. We're talking about Regulation 45. Let's get into it. Okay, so let's set the scene. Imagine you're in the middle of a case at the Strata Management Tribunal. Maybe it's about a leak that just won't go away or a pretty serious defect in the building. The tribunal says, okay, we're bringing in an independent expert to check this out and write a report. And then it happens. That report lands in your hands, and you know this single document could pretty much decide the entire outcome of your case. So you start reading it, and that sinking feeling in your stomach. The expert's conclusions, they just don't add up. You're thinking, wait a minute, did they even see this key piece of evidence? Or maybe they just got the technical stuff all wrong. Or the whole thing just feels totally one-sided. And you're left there just wondering, so is that it? Is this report, this flawed report, the end of the story? Well, I've got some really good news for you. You absolutely 100% do not have to just sit there and accept it. The law actually saw this exact situation coming, and it gives you a very specific, very powerful tool designed for this moment to challenge that evidence and get to the truth. And that tool, it's called Regulation 45 of the Strata Management Tribunal Regulations. Now, this isn't just some friendly suggestion or a guideline. No, this is your legal right to directly question that expert and their findings. It's a really fundamental part of making sure you get a fair hearing. Let's just look at the exact words from the law itself. It says, any party may apply to cross-examine the expert. See that? Any party. That means you. This little sentence gives you the official power to put that expert's report under a microscope. So what on earth does cross-examine really mean? It's not about asking a couple of casual questions. Oh no. It is a formal legal process where you or someone representing you gets to really dig in. You can probe the expert's methods, you can question their assumptions, you can point out every single inconsistency in their report. It's all about making sure their evidence can actually stand up to some serious scrutiny. Okay, so knowing you have this right is great, but how do you actually use it? Well, the process is actually pretty straightforward, believe it or not, but you've got to follow the steps perfectly. So let's walk through it together. But wait, before we jump into the steps, I have to hammer this point home. There is a deadline, and it is absolutely critical. It's totally non-negotiable. If you miss this window, you lose your right to even ask. Simple as that. And here it is, the magic number, 14 days. Yep, just 2 weeks. Seriously, the second that report lands in your hands, a countdown timer starts. You have got to be quick on this one. So circle the date, set a reminder on your phone, whatever you need to do, because you have to move fast. The process really is this simple. Step 1, you get the report. Step 2, sometime within those 14 days, you file an application with a tribunal. You're basically asking for permission, they call it leave, to cross-examine the expert. And step 3, the tribunal gives the order. Now, this is where it gets really good. Look at that word, shall. The regulation says the tribunal shall make an order. In legal speak, shall isn't a suggestion, it's a command. It's not maybe, it's not they might think about it. It means that if you've done your part, you've filed correctly, you're within that 14-day window, the tribunal literally has no choice. They have to grant your request. That's just how powerful and fundamental this right really is. So where does all this happen? Well, there are two main options. The tribunal can decide to have it happen right there during the main hearing, in front of everyone. Or they can decide it's better to arrange it for a separate time and place, in front of an official called an examiner. It really just depends on whatever is going to be most efficient for the case. So you might be wondering, why are we spending all this time on just one little regulation? Well, it's because this rule gets to the very heart of what a fair legal process is all about. It's a cornerstone for fairness, for finding the truth, and for what we call due process inside the Strata Management Tribunal. When you boil it all down, Regulation 45 is there to protect these core ideas. It ensures fairness because you're not just stuck with some flawed report you can't do anything about. It promotes accountability because it makes that expert stand by their work and defend it. and it upholds due process, making sure that everyone gets a full, transparent, and thorough hearing. So, at the end of the day, remember this. Knowledge is power, but only if you actually use it. Knowing that Regulation 45 exists is a huge first step, but the real question is, if you ever find yourself in that tough spot, are you prepared to use this right to make sure justice is really served?